Case 36. McDonagh versus Ryanair. In this case, we find ourselves in the Court of Justice of the European Union, the Third Chamber. Facts. On 11 February 2010, Miss McDonagh booked a flight with Ryanair from Faro, Portugal to Dublin, Ireland, scheduled for 17 April 2010, for €98. On 20 March 2010, I'm not even going to try and pronounce that volcano in Iceland, began to erupt. On 14 April 2010, it entered an explosive phase, casting a cloud of volcanic ash into the skies over Europe. On 15 April 2010, the competent air traffic authorities closed the airspace over a number of member states because of the risks to aircraft. On 17 April 2010, Miss McDonagh's flight was cancelled following the closure of Irish airspace. Ryanair flights between continental Europe and Ireland resumed on 22 April 2010, and Miss McDonagh was not able to return to Dublin until 24 April. During the period between 17 and 24 April 2010, Ryanair did not provide Miss McDonagh with care in accordance with the detailed rules laid down in Article 9 of Regulation 261. Miss McDonagh brought an action against Ryanair before the referring court for compensation in the amount of €1,129, corresponding to the costs which she had incurred during that period on meals, refreshments, accommodation and transport. Ryanair claims that the closure of part of European airspace following the eruption of this volcano does not constitute extraordinary circumstances within the meaning of Regulation 261. But super extraordinary circumstances, releasing it not only from its obligation to pay compensation, but also from its obligations to provide care under Articles 5 and 9. What was the holding? The Third Chamber Court hereby rules. Article 5 of this regulation, establishing common rules on compensation and assistance to passengers in the event of denied boarding, must be interpreted as meaning that circumstances such as the closure of part of European airspace as a result of the eruption of the volcano constitute extraordinary circumstances within the meaning of that regulation, which do not release air carriers from their obligation laid down in Articles 5 and 9 to provide care. Articles 5 and 9 must be interpreted as meaning that, in the event of cancellation of a flight due to extraordinary circumstances of a duration such as that in the main proceedings, the obligation to provide care to air passengers laid down in those provisions must be complied with, and the validity of those provisions is not affected. However, an air passenger may only obtain by way of compensation for the failure of the air carrier to comply with its obligation reimbursement of the amounts which, in the light of the specific circumstances of each case, proved necessary, appropriate, and reasonable to make up for the shortcomings of the air carrier in the provision of care to that passenger, a matter which is for the National Court to assess. The term extraordinary circumstances is not defined in Article 2 or in the other provisions of that reg, even though a non-exhaustive list of those circumstances can be derived from recitals 14 through 15 in the preamble to the reg. European Union law provides no definition must be determined by considering their usual meaning in everyday language, while also considering the context in which they occur and the purposes of the rules for which they are part. In accordance with everyday language, the words extraordinary circumstances literally refer to circumstances which are out of the ordinary. In the context of air transport, they refer to an event which is not inherent in the normal exercise of the activity of the carrier concerned and is beyond the actual control of that carrier on account of its nature or origin. In other words, they relate to all circumstances which are beyond the control of the air carrier, whatever the nature of those circumstances or their gravity. Regulation 261 contains nothing that would allow the conclusion to be drawn that it recognizes a separate category of particularly extraordinary events beyond or extraordinary circumstances referred to in Article 5, which would lead to the air carrier being exempted from its obligations, including those under Article 9. Next, as for the context of and the aims pursued by Article 5, which prescribes the obligations of an air carrier in the event of cancellation of a flight, it must be noted first that when exceptional circumstances arise, Article 5 exempts the air carrier only from its obligation to pay compensation under Article 7. The European Union legislature thus took the view that the obligation on the air carrier to provide care under Article 9 of that regulation is necessary, whatever the event which has given rise to the cancellation of the flight. Second, the regulation aims at ensuring a high level of protection for passengers and takes account of the requirements of consumer protection in general, inasmuch as cancellation of flights causes serious inconvenience to passengers. If circumstances such as those at issue in the main proceedings went beyond the scope of extraordinary circumstances within the meaning of the reg, due in particular to their origin and scale, such an interpretation would go against not only the meaning of that notion in everyday language, but also the objectives of that regulation. Such an interpretation would in fact mean that air carriers would be required to provide care pursuant to Article 9 to air passengers who find themselves, due to cancellation of a flight, in a situation causing limited inconvenience, whereas passengers, such as the plaintiff in the main proceedings, who find themselves in a particularly vulnerable state in that they are forced to remain at an airport for several days, would be denied that care. According to the court, it was necessary to ensure that the interpretation of extraordinary circumstances did not conflict with the principles of proportionality, of an equitable balance of interests referred to in the Montreal Convention, and of non-discrimination, or with Articles 16 and 17 of the Charter. Under a general principle of interpretation, a European Union measure must be interpreted, as far as possible, in such a way as not to affect its validity and in conformity with primary law as a whole.